Greetings and welcome back. This is Chapter 7. We're going to be discussing some crime scene evidence and experiments. This is where we're going to get a little more detailed into other criminal justice professional jobs. This is really intended to touch on the investigatory aspects of a criminal justice profession. Really, this chapter focuses in on real evidence. The previous chapter with witnesses talked about testimonial evidence, and we talked about there's two types of testimony. There's two different types of evidence. There's testimonial and real. Either one can be circumstantial and direct evidence. Most types of real evidence are going to be direct evidence. They're going to be direct evidence because you got the gun that shot the person. You got the bullet pulled from the person's body, or you have the exact drugs that were found on the person during a search. Right? These are all forms of real evidence, and they're directly related, probably, to the crime that's going to be charged. Now, this evidence is also subject to a lot of examination. A lot of examination by both the prosecution and the defense, because we want to make sure this evidence is credible. And it's not necessarily so much about its truthfulness, because it's not going to testify, but it is about its truthfulness in the sense of it is what it purports to be. And for this chapter, I really like the way that it's outlined, but I have a better way that you can understand it. As criminal justice professionals, if you can follow these 4 steps, you're going to help conclude the investigation in a very positive way. The 4 steps is you want to preserve, you want to observe, you want to identify, and then preserve again. What do I mean by that? So your book starts off with preserving, with the idea of setting the perimeter, right? And this is assuming that you are a police officer in some ways, but you could be a correctional officer. You still need to, if you're a correctional officer, you still need to set the perimeter in the event there's some sort of altercation that takes place, or that there is something that occurs with one suspect in the cell. You need to take care of it, and you need to set the perimeter, which would be most likely be the defendant's cell. So you need to set the perimeter, and that's how you preserve the evidence within the perimeter at that point in time, right? You don't disturb the area, you set the perimeter so no one goes in there. Then you want to observe. How do you observe? Well, you can sketch it, you can photograph it, you can record it. And during all this, you also want to actually observe. You want to actually look around, and you want to see what there is. You want to see, is there a gun on the floor? What's in the corner? What's that? Does that look like a little fingerprint on the window? These are all certain things that you need to look out for. You always want to make sure that you get a valid kind of a clear picture of everything just in its natural state. You don't want to just have a bunch of pictures like, well, I took a picture of the window alone, I took a picture of the corner alone, I took a picture of the bed alone, I took a picture of the couch alone, I took a picture of the car alone, I took a picture of, this room alone. Whatever the perimeter is, you want to get a whole picture of it, and then you want to start isolating the areas where you start to believe there's evidence, and then you start taking pictures of those, or you start sketching those out. Or you start if you make a sketch of the entire room, you start plotting it all out. Like, I found this over here in the corner, and I found this on the bed, and I found this in the sink. Depending on whatever the sketch is, So you want to observe the area. Then you want to identify. You want to be able to identify what the object is that you have observed and you think is relevant at that point in time. And it could be anything, but you need to find a way to identify it. And not just say, I found a pen. Well, what is identifying this pen? It has these markings on it. It has bite marks on it. It's broken in 2. You want to identify as much as you can about it. And you want to make sure that there's an accurate picture of it, and that you also find a way to, whatever you're going to put it in, if you decide to collect it, that that container also has some sort of identification. Then you preserve the evidence that you've identified by the container, and making sure that that has a relevant a a unique identifying number, which, it's going to be all standing operating procedure wherever you are. These things are going to be standing operating procedure, the type of identification you make, the way you set the perimeter, the way you observe the area. These are going to be standing operating procedures. You're going to learn these things through training. The last thing, a part of the last preserve, the second preserve, is going to be chain of custody. That is one of the most important parts of preserving the evidence, because if there is a break in the chain, I'm telling you as a defense attorney, I'm going to, in every which way possible, I'm going to attack the credibility that the chain was broken and that in some way the evidence is no longer credible. And the jury's going to hear that, and there's going to be a lot of different ways that you can attack it. And it's not just that there was a break in the chain. That's not necessarily the issue. It's the fact that there's an unaccounted for time, and some way that unaccounted for time affected the evidence in some way. Especially if this is evidence that has a high likelihood, a high probability of contamination. If that's the case, then, if it's that volatile of evidence and there's a break in the chain, I'm going to come up with every reason why, however that evidence is identified in court, I'm going to try to connect the way that it got identified that way because of that chain, right? Not because you identified it at the scene of the crime, but because a multitude of different things could have occurred during that break in the chain that actually changed and contaminated the evidence so that it was capable of identification, which would mean that's not really the evidence you collected anymore. So that's a big issue with chain of custody and making sure you do that. And there's a lot of different ways to do it. The book talks about a lot of ways that you preserve DNA evidence and fingerprints and firearms and the ways you go about identifying these things. But understand that most of this information that you see in this book is not going to be what you're going to learn in your profession. Whatever profession you choose to go into, they're going to be the ones that identify your standard operating procedure and the rules you follow for doing this. But at the end of the day, each one of those standing operating procedures that you're going to be subjected to learn and to follow is going to be a preserve, observe, identify, and preserve process, because that's the best way to kind of make sure the evidence is not contaminated and that it is ultimately protected in time for trial so that it can be used for the purpose it needs to be used for. So make sure that you understand that's really the goal of all of this. That's the goal of the crime scene evidence that you're going to collect as a criminal justice professional. And a lot of the evidence you're going to collect are going to fall into these different types. You're going to get fingerprint evidence, you're going to do blood alcohol evidence, blood typing evidence, DNA testing evidence, controlled substances, and firearm residue. What's really important is all these types of evidence is that if there's a break in the chain, or somehow whatever test that was done to identify this information, identify these types of evidence, if that testing mechanism, whatever machine or process is used, if there is some sort of issue with it, it's going to be attacked so that the credibility of the test itself that identified this evidence for what it is, well, we can conclude that it's not what it says it is. That's the inference that's going to be drawn from it. And it happens a lot, especially with blood alcohol levels. The things you blow into, those are very, very, very contested in court cases, because usually you can't really, defense attorneys are usually very handcuffed into making that argument, because usually if the person was drunk, it's very observable. If you're driving under the influence, most of the time it's observable. It doesn't need a test, actually. The test is really corroborating evidence. But we have an easier time explaining what you saw than explaining what the test said. Does that make sense? What I'm trying to say is that if I'm a defense attorney and my client's been charged with DUI, it's observable that he was probably driving under the influence. That's easy to observe, and those observations, the police uses those observations as a reason to stop him. Therefore, I can't make a Fourth Amendment argument. I can't make the argument that he didn't have reasonable suspicion to stop my client as a defense attorney, because the facts are what they are. If he can testify to personal knowledge that he saw my client weaving in and out of the road, that he was speeding up and slowing down, that he almost hit a person, that he almost hit a tree, that he ran a stoplight, right? These are all things that were observed, and we're going to trust the officer's credibility. So we can't do anything about that. So the stop was good. Then the officer's going to get out, and he's going to run a field test, and it's going to confirm a lot of suspicions that he was driving under the influence. And then he's going to get the blood alcohol blower. We're going to blow into that, and it's going to come back 0.09, 0.10, something of that nature. It's above the alcohol limit. And if that machine is used to essentially corroborate everything and to be the smoking gun evidence. But if I can say that machine was somehow faulty, then I have a better chance of explaining everything else and getting that charge dismissed, because I'm not going to be able to explain 0.10 or 0.09 or whatever. But I can explain why he was weaving in and out of traffic. He was looking down at his cell phone. There you go. The distracted driving, right? That would distract anybody from the road. Well, what about his inability to walk back and forth? That alone is not going to really do anything, Judge. I mean, a lot of people can't walk in a straight line, even when they're sober. It's just the way it is. People were clumsy. It's true. I can explain what the officer observed. I can explain it with kind of, submitting more facts and doing a little investigation, but I can't explain that test result. So the only thing I can do is attack his credibility, attack the actual accuracy of the test. So again, preserve, observe, identify, preserve. If your machine is faulty, get a new one. Tell someone we need a new one, because otherwise a defense attorney will attack it. Fingerprints are the same way. If you observe them, you find them, make sure you take a picture of them, then run your dust test, pull it off, preserve it, send it out, make sure it's documented. Chain of custody is all about documenting the evidence wherever it goes. Don't let it break the chain, because a defense attorney can easily argue that the fingerprint has been contaminated in some way, that there's a smudge in some way, that it's not identifying what it purports to identify because it's been altered in some way, because it's been exposed to too much air, it's been sealed properly, etc. I mean, there are things that you wouldn't even think of. So follow the preserve, observe, identify, and preserve. Understand the types of evidence that are going to really be subject to that process, and the ones that you're going to be more likely to encounter during your career is fingerprints, blood alcohol, blood typing, DNA testing, controlled substances, and firearm residue. That's Chapter 7. I look forward to Chapter 8. If you have any questions, please let me know.